Good morning, everyone. Welcome. Welcome to the Leavitt Group webinar on privacy. This is the first quarter of 2024 Client Foundational Training Series. Be sure to join us for the next one, which will be in June on COBRA and state continuation coverage. For those of you that do not know me, my name is Lisa Nelson, and I'm the Leavitt Group HIPAA Privacy Officer, as well as the Vice President of Compliance and Regulatory Affairs. And today we will talk about how state privacy laws like the California Consumer Protection Act or CCPA may impact your business, especially in light of HIPAA and other major privacy laws that we deal with in employee benefits. So how does HIPAA and state privacy laws interact? That's what we will talk about today. So for some logistics, feel free to type questions into the chat feature. I will stop periodically to take them. There will be a follow-up email within the next 24 hours that will include our slides, a recording, and some supplemental materials and samples. Feel free to reach out to your Leavitt Group representative if you need additional HIPAA resources and templates. We have everything you could need. I'm a little bit of a HIPAA nerd, so feel free to reach out for HIPAA, anything you need. So let's get started with what is really a growing part of legislation in the regulatory world, and that is state privacy laws. State privacy laws are expanding rapidly each year as of late. Privacy is this ever expanding trend. It's spreading across the US, and we must now consider it. And if you have multiple locations, it can really become a complex web of which laws apply and what should I do. So since 2018, 14 states have enacted comprehensive data privacy legislation. 5 of those are currently effective. The remaining 9 will go in effect between 2024 and 2026. Even so, additional state legislatures are considering comprehensive consumer privacy laws this past year, but haven't yet enacted them. And then several other states are passing narrower laws that may govern only specific categories like health or genetic information. So we're seeing it everywhere. Nearly every state is considering some sort of privacy law at the moment. So if you see your state in color on the slide, we will have links over the next 3 slides that will take you to those new laws. I encourage you to take a look at these laws if you have any residents, employees, or customers in those states so that you can consider if they're applicable to you or not. So over the next 3 slides, there's going to be links as well as the effective date. You'll see on this slide, these are the most recently enacted laws. So the 5 that we're talking about are on this slide. They were mostly effective last year. Most of these laws are really easy to read comparatively. Regulatory rules can be very cumbersome and hard to get through, but these laws, they're actually pretty easy to read. State regulatory rules are a little bit easier than federal. So I do encourage you to take a look at them. We are going to go over a little bit more detail in the California Consumer Privacy Act and its corresponding California Privacy Rights Act as well. We're going to talk a little about that today because it is one of the far-reaching rules, and as a result, if you were to comply there, you're probably going to be compliant elsewhere. So as you'll see, the ongoing effective dates of these new laws, they're trickling every few months. There's a new law that's effective as it relates to privacy across the US. So if you're a multi-state company, then you have a lot of states to keep an eye on. So all of these slides have active links. When you receive these slides in your follow-up email, you can just open it and click right to the link. Make it nice and easy for you. So a heavy lift in privacy is CCPA. CCPA is the most robust and prescribed state privacy law that we've seen come out of these state privacy laws that we see spreading across the US. And it's unlike other state privacy laws that exclude employees from the definition of consumer. So for example, the New York Shield privacy law doesn't include it doesn't apply to employees It also doesn't apply to revenue thresholds based on a control group. It'll apply based on individual entities. It applies to nonprofit, but CCPA doesn't apply to nonprofit. So there's going to be differences between the laws. New York Shield is a pretty big law, but California Consumer Privacy Act is a bigger law. It's really recommended if you're multi-state to try to take a really conservative approach to how and when you comply with state privacy laws. For example, if you know you have to probably comply with California, try to comply conservatively to California. If you're complying with California, you're most likely going to be complying elsewhere because it is a broader, deeper law with more rules than many of these other state privacy laws. So the next closest privacy rule in the matter of intensity is the European Union's General Data Protection Regulation, or GDPR. This happened a few years ago, and it's very broad and deep. If you have a European location, you would be familiar with this because it is a very broad and deep rule. But it regulates different entities. So GDPR regulates the data controllers and processors of data, where CCPA will regulate the employers of California residents, consumers, or companies that have consumer data on California residents, job applicants. So it actually reaches a little bit further than a law like GDPR would even do, which is pretty broad generally as well. There's a revenue threshold for CCPA of 25 million. If you're a part of a franchise or control group structure, however, don't think that that gets you out of it because if you're a larger entity, if there's some common control or influence, would therefore impact the smaller entities and make them have to comply as well, because the CCPA does have a franchise rule. This rule that says, sorry, excuse me. This rule says that any entity that controls or is controlled by a business that has common branding, that has some influence over the voting class or management of the company, that commonality will make those smaller entities within the group have to comply with CCPA if the larger entity has to comply because they meet the revenue threshold. So keep that in mind. Joint ventures, common control may open you up to some CCPA compliance, even if you're living in a different state, even if you're located in a different state. That doesn't mean California CCPA doesn't apply to you. All you really need is California consumer data or California employees, and this rule may apply to you. The revenue threshold is a consideration, and if you're a part of a control group, will be part of a consideration. But don't think that California being part of the title means it doesn't apply to you if you reside outside of California, because it still may. And there's two ways. If you have any employees, even remote employees, if you have one remote employee in California, then CCPA will apply to you. Or if you have customers and you have any of those, any data points on a California customer. So if you are a company and you contract with another company that has California residents and you have access to those California resident data points as part of your contract with that business, CCPA will apply to you. So it goes much deeper than a lot of other laws do to really try to touch more entities and make them comply outside of California than before. So consider that franchise analysis when you're looking at CCPA and whether or not it complies. What you have to do is slightly different between the two buckets. Are you an employer of a California resident, or are you a service provider to a California client? They're slightly different, but a lot of similarities. Data minimization. That means take less, use less, share less. If you don't need that data point, don't have it. Don't take it in. Don't store it just in case. You don't need it. Don't need it. That's data minimization. There's also consumer requests, and you're responsible for responding to those requests, and we'll touch on that in a minute. If you have a public-facing website, there are some requirements for that compliance of that website, including things like do not sell and posting a privacy policy. If you have any websites that may reach California consumers, it's really important that you have a compliant website. That is because that is a low-hanging fruit. If a lawyer really wants to become the next ADA, you know how ADA lawyers and those ambulance chaser types used to go around, check buildings for ADA compliance and sue. Well, they're doing the same thing for CCPA compliance, but it's much easier to identify because all they have to do is go on a website. There are websites that allow them to plug in a website. I think it's blacklight.com. And you plug in a website, it'll tell you if there's Google Analytics in that website. It'll tell you other things that would identify whether or not that. So if you have a web page that reaches California consumers and CCPA may apply to you, that website compliance is going to be really important to you. If you have residents in California employee residents, there are also additional notifications that go to them. If you have job applicants in California, you have to have a specific notice about collecting certain information from job applicants. You have to have a notice of financial incentive if you have a wellness program. And you have to respond to your consumer requests. If you have any physical locations in California, you should also have an on-site notice of collecting consumer data. If you have any security cameras on your property, if you're collecting names for sign-ins at your office, all of that collecting of a name, of an image, of an email, all of that is collecting California consumer data. And when you do that, there's a notice requirement that comes with that says, I am collecting this for this reason, and this is how I protect it. So those all come from CCPA. So there is some good news. Not all data is CCPA data. So all personally identifiable information would be, so that's nearly any type of information. And anything that's publicly available, we can sort of exclude, right? If you can access that easily publicly, then we don't have to worry about it as much. But every other personally identifiable data point would technically fall under CCPA as a consumer data point. But there are exceptions. Some data points would be excluded from the law because they assume other laws are covering it appropriately. Things like HIPAA. So when we talk about stuff in employee benefits here at the Leavitt Group, we talk about HIPAA a lot. And the PHI, the protected health information, we'll talk more about this later, is protected under HIPAA, so CCPA doesn't cover that. But it will cover other types of health information that maybe falls through the crack of HIPAA. So either way, we have laws that are sort of laying on top of each other, hoping to collect and catch all of the gaps in data points. But things like the Graham-Leach-Bliley Financial Information Privacy Act, the Driver's License Privacy Protection Act, these are all data points that you collect in things like job applications and employment records. These things would be excluded from CCPA, and that'll be important later down the line. So when that means when we have a consumer request related to that data, we don't have to comply with that consumer request because CCPA isn't talking about that data. It's talking about something else. You would have to comply for that other data that CCPA is talking about. Hope that makes sense. Okay, I'm doing super high level because we only have an hour. I could do CCPA for hours. It's a very big, robust rule, and we have additional resources for you. So if you do want somebody to consult with you, we also work with Fisher Phillips, our preferred partner for employment law. They have a package that really is turnkey. If you really need a resource like that, we have those resources available to you. Just reach out to your Leavitt Group representative and we'll connect you to that resource. But at a 10,000 foot view, this is what CCPA will require of an entity who must comply with CPA. Training. So you need some basic level of training. This is a very basic level of training, but if you are going to have to comply with CCPA, you'll want more training than this because I am going high level for you. You'll need to start doing a data inventory and mapping. And this one is challenging. As someone who's who's gone through it, it is a challenging process. It takes a lot of time. And what it's asking you to do is to identify each piece of data that you have and where it would live and who you're sharing it with. So if you have a name, where does names live? You might save it in this folder, in this software. You might share it with this service provider. Therefore, if at a later date we have an individual who wants something to happen to that data, like delete it. If you have to delete it, you need to be able to say name lives here, delete it here, shared it with this person to have them delete it. So that's why they're mapping the data points so that you can actually comply with a consumer request as it relates to that data point. So as much as possible, you need to map each data point. So name, address, social security numbers, these are all data points. Your website compliance, you need to have a CCPA privacy policy. There needs to be one posted on your California resident consumer facing website. So there should be an opt-out, do not sell my information there as well. So make sure your website is compliant. You have to be able to respond to CCPA requests. We're going to talk about this in a minute. Data minimization, we talked about a little bit. There's notices I talked about really quickly, job applicants, employees, the financial incentive if you have a wellness program. Vendor management, make sure that your service providers are also being CCPA compliant if you have to be CCPA compliant. So you should have an addendum or some sort of CCPA contract with them that says that they would agree to do what you're required to do under CCPA, which may include deleting data points where required to. You should have an employee handbook if you have California residents that are employees that includes their rights under CCPA and your policies and procedures as well. So if you work with someone like Fisher Phillips, who I do recommend because they're really good. If you work with someone like that, they should be able to give you those templates of those policies and those notices. I know Fisher Phillips does. So hopefully you have a resource like that and we can help provide that for you if you need a connection for that. And the reason these are important is because the individuals have rights under CCPA to ask certain things of you if you have their data. Things like they want to access the information that you have. They want to know what you have on them. They want to opt out of you selling or sharing, not just selling. It used to be selling in the beginning of the law, and then it morphed into just sharing even their data. They can request that you don't do that anymore. They can request that you limit the use of any sensitive, personally identifiable information. And the most severe would be the request to delete all the information you have on them. So those are the consumer requests that are embodied within the law, but there are outs, I would say. You don't have to comply with every request that comes across your way. So that's good news in a sense. A lot of work to be done for nothing at times, but you still have to go through the process, unfortunately. So you can deny a lot of requests if it would be unwise to delete a record, for example, because you need to maintain your employment or business records, and it's reasonable that you have to retain those particular records. And that's why you never actually fully delete here. You can get to almost deleting, but you're never required to go back into your archive and search them out to find them and delete them. That's considered likely burdensome. So you don't have to go that far, but you need to go as far as possible to comply with their requests. But there are some outs, and I'm going to talk about this in a minute too. So there is a prescribed process. So if you get a consumer request because you posted on your website that you have this privacy policy, you have an opt-out because you're all required to do that. And then they come to you and they via telephone, they could do it by email, they could do it by web form online, or they could even walk into your office. These are all acceptable ways for them to provide a consumer request. Once they give you that request, you have 10 days to acknowledge it, and then 45 days to actually effectuate it, or 90 days if you get an extension. Or let them know why you couldn't. So if they requested that you delete their records, you acknowledge it within 10 days, and within 45 days, you either delete their records or you tell them why you could not delete their records. And you could have several options. You name each of them that apply. It could be, we haven't verified your identity. This one is like step one. If they provided an email to you, and I've gotten this from Privacy Hawk recently, I don't know if any of you out there have, but I've been getting requests via a Privacy Hawk, which is an automated online system that sort of identifies everyone that might have your information and requests automatically that they delete it. Without verifying the identity of the person with just the name in the email, that's not verifying their relationship with you. And so you don't have to actually comply. So you could say unverified identity. You could say we need to retain it to help secure business records or employment records. We need it for legal proceedings. We need it to for the integrity of our network system, or to otherwise comply with already reasonably aligned expectations of the consumer. So depending on why you have that information and what that data point is, there may be a reason why you actually have to retain some of that information, particularly employment records. So you can deny a lot of requests for any of these 8 reasons. CCPA does have some anti-avoidance rules and individual rights to sue for breaches or non-compliance. And California has taken themselves quite seriously on this, but it's only really begun fully expecting businesses to comply in this last year. The CCPA penalties have begun for some like Sephora, who failed to have their full website compliance and consumer response. For retailers in particular, Google Analytics and tracking will always trigger CCPA compliance because you're just tracking them. You're collecting data points automatically on them. And that's really what CCPA is intended to target, although they are sort of sweeping in a lot of other businesses in their intention to target mostly retailers. So either way, it impacts you. Keep in mind that there are anti-avoidance rules and penalties that include personal rights to sue, in addition to the Attorney General of California's right to bring in enforcement action like they did with Sephora. This is the website for CCPA and also where you could submit complaints. Okay, I'm going to pause here to see if we have any questions specifically on state privacy or CCPA. As we wait, there's a list of articles that will be active links in the slides that I'm sending you after our presentation today that will take you to some of the articles that we've written on CCPA. A lot of them are very helpful in determining whether or not CCPA will apply to you. I know I went super high level today because I only have a short window of time to speak to you. So this will help fill in some of the gaps. So these are the articles listed on this slide that will help you there. Let me see if there's anything in the chat. No, I'm being very clear. Okay, good. Nothing in the chat. Okay, and so we'll move on to part 2. Okay, So while I'm not your HIPAA privacy officer, I will be working with any of your Leavitt Group representatives to ensure that you understand and comply with what I call the funnest regulation of all. And those of you that know me know what I'm about to say. Hip, hip, HIPAA, hooray! What other rule can you say hip, hip, hooray to other than HIPAA? So obviously it's the funnest regulation of all. So I've been working with HIPAA since 1999. So I started when I was 12. First in the hospital setting, and now as a compliance advisor. And I do love HIPAA, so you might see me geek out a little bit on the HIPAA topic in particular. So it is possible to love HIPAA, but the rules do not ask that you love HIPAA, but it does ask that you engage with the rules. I will, for easier consumption, oversimplify during this presentation. Will common practice will allow. I've included a lot more on the slides than we may even have time to go through. I wanted to give you a little bit more so that afterwards you have some materials that you could review. Feel free to reach out to your representative. I'm happy to provide more details to you. I am accessible to you if you had specific questions around HIPAA and your needs. And then I'm going to share some HIPAA audit checklists, as well as some other materials that I talk about during this presentation with you after today's meeting as well. So HIPAA is a category that, for those of you that aren't intimately involved with it, may call what I call a HIPAA foul when there is none. So today we're going to talk about some important details to make sure we don't have any HIPAA fouls. And I like to start with the top 3 takeaways today. Before I lose your attention, I'm going to tell you what the top 3 takeaways for HIPAA will be. So number 1, training. Congratulations, you've made it to training. So number 1 for HIPAA is your basic reminder that the basics of HIPAA starts with HIPAA training. Whether you're hands-off PHI or hands-on PHI, training is flexible. It's dependent on how much PHI you engage with. For insured plans who the majority of PHI actually lives within carrier partners, there is a requirement to consider training about how the rules may apply. For self-funded plans, HIPAA does apply. And so training should be more regular for self-funded plans, whereas insured plans could engage in less regular training if they remain a hands-off employer. And we'll talk more about that throughout. That means don't help intimately with claims issues. If you're helping intimately with claims issues, you cannot call yourself a hands-off PHI person, because you are taking in voluntarily PHI and helping people with that instead of just sending them to the carrier to figure it out. So you can help with enrollment, basic questioning, triage, but once you start taking in PHI and talking about it with third parties, then you can't say that you're hands off anymore. Retraining should occur if there's been a potential security incident warranting reexamination, if there's a new hire, there's a change in the law, if there's a change in the organization that may impact the HIPAA's impact to the organization. In all of those cases, you would also retrain. It's also a good idea to consider using quarterly engagements to remind your employees of the HIPAA rules throughout the year. So if you're conducting that less regular training, such as biannual training, it's a good idea to use another method to train staff ongoing in between. And quarterly engagements are a good way to do that. You could do a game, you could do memes, you could do a funny video, you could do little flyer reminders. These are just a couple examples that I've used. So it's a good idea just to constantly engage. Some places, some of our locations have on all their computer and TV monitors reminders ongoing. So think about ways that you can constantly reinforce the rule. You may have don't share your password on the screensaver or something like that. So think about ways to engage. So number 2, don't forget to obtain your business associate agreements. So a business associate provides a service to the covered entity. And by way of providing that service, they have access to and use and disclose and share PHI. on behalf of the covered entity. So it could be a consultant broker, it could be attorneys, auditors, it could be your shred bin company because you put all your sensitive information in a shred bin and they have access to it. It could be whomever's helping you with any of your self-funded components like your HRA and HSA and FSA or EAP. So think about who you might be employing or enlisting or hiring to help perform services on behalf of your health plan. And because of their help there, they're considered a business associate because you're sharing your PHI on your employees with them. And you need a contract that says that they will protect that information when they are using and sharing it, just like you would have to. So that is called a business associate agreement. So your TPAs, if you're self-funded plan, are clearly your business associates, but stop loss carriers are not, because they're not really anything other than a bank or a funding mechanism. So think about whether or not there's a persistent ability to access PHI, specifically PHI, in that business relationship to determine if they're a business associate that has to have a business associate agreement in place. So you want to obtain this typically at the beginning of the relationship before you're sharing any PHI with them. You want to maintain it in usually a central repository that's accessible by your HIPAA privacy officer and leadership, because if there's any incidents involving that business associate, you need to be able to access that business associate agreement quickly to see what the terms are for the what ifs. What if they had a breach? Who does what, when, what's the timing, who's the responsibility? That's all outlined in your business associate agreement. So it's important that you have that, because the companies that you're enlisting and employing to help with certain services may not have to comply with HIPAA directly. Therefore, the only way they'll have to comply with these rules is via the business associate agreement. So it's very important that you have that agreement in place to ensure that they're going to comply with HIPAA at the same level that you do. Now, if you have a business associate that then hires another entity, then that's a subcontractor that they have to have a business associate agreement signed with. Whomever's bringing the individual or the entity to the party has to get the agreement signed. So for example, if you had a wellness vendor that you hired and they hire a biometric screening company to help them fulfill the contract that they had with you, then they would get a subcontractor business associate agreement signed with that biometric company to make sure that that downstream contracting and those obligations are flowing. So there's no direct duty to monitor them and to make sure that they're always in line. Your obligation would to me make sure that everybody has the contracts in place. Your BAA with that business associate says that they have to have a subcontractor BAA in place, and therefore by contract you have done everything that you're required to do. Now, if something happens and you become aware of it, you can't turn a blind eye. You have to do something, but you don't have an obligation to go in and make sure that they're doing everything. Your obligation rests with ensuring that you have the contracts in place. The number 3 takeaway for HIPAA today would be potential or security incident reporting or notification. What happens if? What happens if something goes wrong? We all do it. Everybody makes mistakes. It's important to know when something happens so that you can figure out the ways to make it less likely to happen. So even if you think something may have happened, might not have happened, a concern, it's important that that's reported to the HIPAA privacy officer at that organization so that they can start putting in place things to minimize the likelihood that that error could happen again. So if there were indeed a breach or some security incident, you have to have a privacy officer within your organization. If you're a covered entity, you must have a privacy officer. And then the report should go to that individual. That individual would also be responsible to ensuring that the policies are in place, the training is being done, everything that we're talking about. But step 1 would be reporting to the privacy officer. That individual would be doing an investigation. documenting that investigation, and conducting a risk assessment about as to whether or not that particular incident would likely cause harm to the individual whose information was involved. It could be reputational harm or otherwise. So that assessment is done by the privacy officer. If, I'm going to pause here, if you're sitting there thinking, I might be a privacy officer, I have no idea where to begin. Good news, you have a friend in me, I can help. And we have flow charts, we have templates that we can help you with. So don't be afraid on this one. You do have support here at the Leavitt Group on this. We can help walk you through the process if you have something like that happen. If you do have an outcome that there could be harm to the individual based on who accessed the information, how it's accessed, what it was accessed, how long it was accessed for. Based on all of those factors, if there's a chance of harm to the individual, then there is notification requirements. That individual has to be notified within 60 days of the incident. If it is a material breach, involving 500 or more individuals, a massive breach. So if you're a large company, that could happen. The media is also notified within 60 days, and they can decide whether or not to tell the rest of the world of the breach. But this is why we see breaches in the news. It's because it's required that the media is notified. And then it's important to understand the process of reporting. So if you are the covered entity, the health plan, and you have an entity like your wellness vendor who had the incident, the breach, and via your business associate contract with them, they had a breach, they had to notify you within 10 days of that breach. Now you, as the plan sponsor who owns that information, or your employees own that information, now you've been notified that wellness vendor had a breach. You can determine whether or not you want wellness vendor to tell your employees that they had a breach, or whether or not you want to tell your employees that they had a breach. Most of the time we tell them to do it, but it's up to you because it flows from business associate to covered entity to the individual notice requirements, which is the affected individual, Department of Health and Human Services, and the media. It's also reported to the Department of Health and Human Services because it is posted online. So if you have large breaches, it's all posted online. You report online also at this link here. So if you had any breaches, you would go to this link and submit your report to the Department of Health and Human Services on that breach. So there is a reporting structure. This is super high level, I know, but I'm just giving you enough to understand that there are elements here to be aware of if you have an incident. Once you get into the weeds of it and you need some additional support, let us know, and we'll be there for you through it. But you can take a look. This is actually from 2 days ago. It's a recent clip. So you can take a look at and see who's had breaches and what's the incidents. A lot of hacking incidents these days, a lot of them. Okay, so let's do a mini HIPAA training. For those of you that need HIPAA training, we'll spend the rest of our time giving you that mini HIPAA training so you can check the box. I have been HIPAA trained. So those of you that are fully insured, this is probably a good enough HIPAA training for you for now. And then reconsider in another year, or if any other changes to your health plan happen, whether or not HIPAA would apply to you. So HIPAA is a category that sometimes we get confused around. So it's HIPAA, not hippo. That's just a little bit of a pet peeve for HIPAA people, is to use two P's. It's not two P's, it is two A's, one P. So HIPAA, not hippo, is the health insurance portability, meaning you can take your insurance with you, for those of you that know about COBRA, and Accountability Act. You're accountable to protect the information if you have access to it. So that is HIPAA. Now, HIPAA also had some amending regulations since the beginning of HIPAA in the 90s. We had high tech, which is a lot of security rules and electronic network rules. I'll spare you those details. They're all basic understanding in today's world. HIPAA does not fully apply to all health information. We'll talk about more about what kind of health information in a minute. And it doesn't apply fully to disability plans, workers' comp plans, and life insurance plans, because the free sharing of information is a little bit more necessary in those particular plans. So we have a little bit ability to share more information in those plans without an authorization than in other health plans. HIPAA privacy is paper, orally communicated, and HIPAA security is all the electronic versions. Now, if you have any electronic versions of PHI, then HIPAA security is going to apply to you. That means you have to worry about cybersecurity training. You have to make sure anybody who's accessing your computer networks that has access to any of that sensitive data has cybersecurity training. So privacy, all of HIPAA, security, electronic versions, and wider concern with that electronic versions, with the amount of hacking and IT incidents happening. Department of Health and Human Services is paying closer attention to that security circle. So cybersecurity stuff, you really want to nail down. You want to make sure you have a good cybersecurity plan, that you have an IT person who is well equipped to understand how to secure your networks if you have sensitive data on them. So we talked about PHI a lot. So what is PHI? Because PHI is specific. We're not talking about all types of health information. We're talking about protected health information, a specific category of health information. And it covers most individually identifiable health information that is held or transmitted by a covered entity, which I'll tell you next, or its business associates. It needs 3 factors to be PHI. It has to be created or received by a covered entity. It has to be relating to an individual's past, present, or future medical condition or payment for. And it has to be identifiable. If you remove any one of those, it's not PHI anymore. So let's say if it wasn't created or received by a covered entity, then we just have some medical information that may be protected under state privacy law. Less prescribed, less cumbersome, just a general law that says, in most cases, if there's a breach, notify. Most cases, that's the limit of the state privacy law, not HIPAA, which is a really big law. If you remove the identifier, then you just have health information that was created by a covered entity, and it's de-identified, so you don't even know who it was. And de-identification is an appropriate way to get around the HIPAA rule. If you can remove the identifier and still use that data, then you can get around using HIPAA, worrying about an authorization, worrying about the rules. So for example, if you are an HR person who is helping an individual with a claims issue, you could contact your carrier and say, I have an employee who had an amputation and they said it wasn't covered. Are we not covering amputations? There, you didn't even share the identified person. Think about if you need to share the identifier at all. If you can remove an identifier or remove the medical information from the conversation, then you can get around the rules some a little bit. HIPAA obligations will flow if you're a covered entity directly to you, or it could flow to an entity via the business associate agreement. Because remember, a lot of companies aren't covered entities, but they may have health information. And that's why they need that business associate agreement to make them comply with HIPAA when they're sharing and using your protected health information. Now, we have a lot of health information that comes our way via our health records. Our employment records, our sick notes, our leave. HIPAA is not concerned about that because it is not being created or received by a covered entity. A covered entity is a healthcare billing house, a healthcare provider, and a self-funded plan. That's a covered entity. It's not all the other places that may have health information. It's only those 3 items. So if you're not one of those, then you're likely falling under an employment law or state privacy law that's less robust. So think about if you have your employer hat on when you're hearing that health information, or do you have your plan sponsor hat on? If you have your plan sponsor hat on when you're talking about that health information, you're likely going to be covered under HIPAA. If we have our employer hat on because we're doing sick notes, workers' comp, workplace injury, those are all employment law functions, and HIPAA does not comply, is not concerned with those. But other rules may be concerned with those. So we don't want to forget that when we say HIPAA doesn't apply, it doesn't mean nothing applies. It just means something else likely applies. Because when we're talking about health information, something usually applies. So we have the ADA that applies directly to you. And that most of us are familiar with. And the major difference with the ADA, other than on-site safety things, is the records have to be separate. So if you have a medical record in your employment file, it has to be separate from the rest of your employment file. And then you have a HIPAA super secret file, I like to call. So your file will be separated depending on what that information is. You have your employment file, you have your employment sick medical file, FMLA note file, that's separate from the rest of your file. And then within that file is another file that says it's HIPAA. So that would only be claims information or anything related to when you had your plan sponsor hat on. So ADA requires that you keep some of those files separate. You'll also want to consider if the state privacy laws apply. We went over this a little bit, but always keep in mind, HIPAA is the floor. You can build upon HIPAA if it's a more restrictive law. If HIPAA does not cover that, obviously you can regulate around that. But most of these privacy laws are not as restrictive as HIPAA. If you want to read an article, we have an article that did explain a little bit more about the interaction of state privacy laws, and that's linked here. So privacy, I break up into 5 sections, and we've talked about some of these already. But what I want to draw your attention to is the individual rights section on this slide. Privacy provides individuals with the right to ask that you restrict access to their PHI, that they access their records, that they receive an accounting of how their PHI is being used, and that they amend their records, and they have no retaliation fear for exercising those rights. But just like with CCPA, there's a lot of buts in these rules. And so, yes, you can ask that you restrict the use of their PHI, but only if it's for a claim that's already been paid. And for most of us, when we're in the process of what we're doing here at the Leavitt Group and consulting in our health plans, the claim is usually not yet paid. They have a right to access their records, but only where there's a required accounting of the records, and there's only a required accounting of the records if you're using their PHI for something other than payment, treatment, or operations. Most of what we do is for payment, treatment, and operations. So only if you're dealing with a little bit of claims issue can I envision this coming up, but in what we do here, this doesn't really come up. And they can ask for an amendment to their records, but you're not required to comply. So they have rights with several rebuttals available, and they're made aware of their rights through the notice of privacy practices that must be sent out. If you're part of the Leavitt Group community, we provide a packet to you that includes this. There are several models. It might not look like this one, but there are 3 models that the Department of Health and Human Services provides. If you're an insured plan, it's likely being done through your insurance carrier provider. Another important part of HIPAA is the restriction on the use and disclosure of protected health information via the minimum necessary standard. So HIPAA, what is that? What is the minimum necessary standard under HIPAA? I can't tell you. Just kidding. Just kidding, I'll tell you. The minimum necessary standard dictates that you use and disclose only the minimum amount necessary to complete your task. So you really have to consider, do they need to know it? Do I need to share it? Do I need to retain it or even take it in? Don't even take the record and file it just in case. I've heard that before. We don't need a just in case file. If you don't need it, don't take it. Think about how much you really need, how much you need to share, and limit who you're sharing that information with. So for example, going back to Jane Smith had an amputation, cost $5,000. If you're trying to figure out why that claim wasn't paid, you might not need to say that it was for an amputation. You could just say that it was for $5,000, or you don't have to say it was Jane Smith. You can just say you have an employee who had a claim not paid. So think about where you can remove information in the conversation. When you are helping with claims issues in particular, and you have to share PHI with a third party, somebody outside of your business associate agreement contract relationship, somebody outside of your insurance carrier relationship, some other third party, including if it was a husband or wife who called, then you need an authorization form. And this is your permission slip to share with a third party somebody's protected health information. So this is required outside of the business associate covered entity relationship. Anytime you're talking about psychotherapy or substance use disorders, an authorization is also required. So think about whether or not this is needed. I will be sharing with you a template in your follow-up email, so you'll have that on hand. Now, I mentioned HIPAA security is really important right now. This is where regulators are really focusing, and this is because the amount of hacking is been intense. If you're not aware of what's happening in that world, you've heard of it on the news some, but it's been a lot of hacking of businesses. So I'm not going to go in a lot of details. This will be in your follow-up for you. But I outlined the basics, and most of this is kind of standard procedure these days. Most of the cybersecurity rules should be standard and you should be doing it. But I just highlighted a few for you that may need some attention. Disaster recovery plan is often forgotten. If you don't have a what happens if plan, then you're not fully HIPAA compliant. You need a what happens if plan. So if you have a computer system with your network and it lives in this building and there's a fire in this building, what happens to that system? How is it secure? How is the data on there secure? That's your what happens if for security requirements. Make sure that your documented policies are up to date in your training on cybersecurity. Make sure if you have on-site visitors where you have access to PHI on your computer systems, that they are escorted. You are required to do a risk analysis to determine where your risks lie. So whomever is your IT technical person should be able to conduct an audit of your system to identify weaknesses. It's important that you patch things immediately. The incidents of hacking happen more often when there are patches that are not implemented in your security network system. So make sure that that system is up to date with all of its security protocols. So let's talk about everyone's obligations. Everyone is obligated to understand what the state privacy laws as well as HIPAA. Everyone is required to be aware of them. If you're at this presentation, you're probably in employee benefits world, you need to know what these rules are. You need to have somebody appointed to understand these rules, to take charge of this, somebody who's going to do the training, who's going to understand and analyze whether or not it applies to you. You have to have a secure location for any sensitive information, whether we're talking about your employment files or whether we're talking about your HIPAA protected files. They need to have a secure location. It needs to be locked away. If they're electronic folders, they need to have restricted access. Nobody should have access to everything in the system other than the IT person. There should be restricted folder access for all of those important folders. Stress less, use less. Like just use less. You don't need all that information. Think about where you can eliminate some of it. And there needs to be a HIPAA certification in your plan document somewhere that basically says you comply. And it's in standard plan documents most places, but it's just something to know in case you haven't been aware of that one either. And a self-funded plan or insured hands-on plan, make sure you're doing that security and privacy training. This should be regular. Annual is recommended. If you have like an HRA that you're administering yourself, consider maybe even more engagement with the HIPAA rules, because HIPAA is very much concerned about you administering your own HRAs. Make sure that you're using encryption if you're using a lot of PHI or password protection if you're sending a census over the internet and you don't have encryption. Make sure you're aware of the breach notification rules and that you're complying with the timeframes for any incidents should they occur. And make sure that your networks are fully compliant. Now, do a risk assessment and vulnerabilities test on your security of your network. Now, if you're a hands-off insured plan, this was your training, easy peasy. So just do some training on your HR benefits team. Those that come across sensitive information, even if not HIPAA, they should be trained on how to handle sensitive information, and HIPAA training is often a good way to do that. You can be HIPAA compliant even if you're not required to. Make sure that you're aware of the rules of protecting sensitive information wherever you come across it. Periodically check in. I would check in every couple of years unless you have a change in your health plan. If you go level funded or self-funded, well, guess what? Now you have to become fully HIPAA compliant. And remember, self-funded includes having a self-funded component. You can be a fully insured plan, but you add an HRA or an FSA or an EAP to that fully insured plan. These are self-funded. These require you to be HIPAA compliant. So don't forget about those components that are considered self-funded that may trigger your HIPAA compliance obligations as well. Okay. So what is the disease you get from too much HIPAA? I hope you did not get this disease today. This is incurable, I know, because I have hepatitis. Yes, I do. I have hepatitis. Okay, let's see if we have any questions. Okay. I tried calling our dental providers for an employee this week and asked about a waiting period. Their rep said it was a HIPAA violation. I wasn't able to ask of this. Is that correct? I didn't ask any personal information. Well, listen, it depends. If you're a small self-funded plan, they can tend to be very tight-lipped. Now, this is a basic question, what the waiting period is. I would imagine they could have told you that even without asking who the individual is, because it should be the same waiting period. Now, if there's a waiting period for a particular procedure that was specific to that individual, then I can see why they didn't tell you, because it's specific to that individual. But if we're talking about a waiting period for the plan, that has nothing to do with the individual. You should be able to get that information. Now, if it's for the individual, they're going to be tight-lipped if you're a small or insured plan. They just tend to do that. Sometimes they say that even when they could share a little bit more, but it depends on the provider. Some a little bit more tight-lipped than the others, or conservative when it comes to HIPAA. Okay, any other questions on HIPAA? Thank you for joining me today. If you have any questions afterwards, feel free to reach out to your Leavitt Group representative. We will get you a response. Look for that follow-up email and the supplemental materials in there. And if you have any questions, please reach out. My email is there. Reach out to your representatives too, and we can get you any additional support you need on privacy to make sure that you have everything that you need to feel compliant with all of the privacy laws. Thank you for joining me today. Oh, wait, one more question. If you send a list of employees without names, but has date of birth and age, does that have to go through secure email? Now, when we're talking about state privacy laws, those are important data points. So I would still prefer that that goes secure. And it may not maybe not because of HIPAA, but if you have date of birth and age alone, without any other information, that alone is not enough information for HIPAA to be concerned with. But it is for CCPA. It is for other laws. So be conservative when it comes to sending secure information. It's always just wise to be conservative, because if you send it secure, even if something happens, you're off the hook. So consider ways to secure it, even if you feel like it may be overdoing it at times. Hope that answered that sufficiently. Okay, thank you. Have a good rest of your week, and let us know how we can support you. Okay, bye-bye.